Good morning. This is Judge Elisa Bettis presiding over the 210th District Court Civil Docket for August 2nd, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our first case, please?
Judge, may I? Erica is logging in right now, Judge.
Oh, okay.
I'm here, Judge. Thank you.
Okay, thank you. Let's go.
Second on page 1, Judge. In cause number 2021 DCV 2365, Farah Olivia Jones versus Jose Renteria Lopez et al. Announcement of counsel, please.
Good morning, Your Honor. Manny Morgan on behalf of Ms. Jones.
Good morning, Your Honor. Rogelio Morales on behalf of Clifford Joseph for defendant Progressive.
Entry of judgment. Looks like we've been here a couple of times. What's going on?
Your Honor, we submitted the order, so I think it just needs your signature.
Do you know when you sent it?
It probably this morning.
2365.
And if not, I can resend it.
If you would, please. I don't see it. Myrna, do you have it?
Judge, she's having issues with her audio.
I can resend it, Your Honor. That's no problem. But
Okay.
it should be down here shortly.
Okay, thank you very much.
Thank you, Your Honor.
What's next? Y'all are excused if you don't have anything else. Have a good day.
Thank you, Your Honor.
Top of page 2, Judge.
Was top of page 1, was that one already taken care of? 2625?
My understanding was that it was filed. I don't know. I haven't talked to confirm with Myrna, Judge.
Okay. All right. Go ahead.
In cause number 2020 DCV 2345, David Jones versus El Paso Cowboy Construction LLC et al. Announcement of counsel, please.
Robert Rios for the plaintiff, David Jones.
Albert Beal for Cowboy Construction.
How are we doing on this one? Do we have Mr. Jones?
We do not have Mr. Jones, Judge.
Okay.
I mean, we have him, but I guess I could say I know where he is, but I don't know. I don't.
Somebody
physically
else
have-
has him. Somebody else has him, I think.
He's
right?
he's being well fed and those sorts of things. But to give the court an update, Mr. Beal and I talked about trying to get this mediated with the dispute resolution. His client apparently is uninsured. And so we've talked about some numbers, but I think we might need the assistance of a mediator to get us closer to what I've been in contact with Mr. Jones infrequently because of his situation, but that's all that I can report to the judge. I wish I had more positive information, but as you know, we did get it settled with the other defendants, but I'm hopeful that Mr. Beal and I can work something out.
What are you asking for, Mr. Rio? Has a referral order? I see we have a mediation deadline for October 3rd. I don't know offhand if there is some type of order related to that or if we just kind of set it. Is that what you're asking for?
No, Judge. I think what I'm asking for is just to get some more time to. It's difficult to communicate with Mr. Jones, but I have received some correspondence from him, and he, in fact, sent me a letter identifying someone who would be willing to or who's able to communicate with him more frequently, a family member or a friend who has the ability to call him or receive calls from him. So I'm not sure what the judge wants to, or what the honor wants to do as far as our court hearing, our trial that's set in October. Honestly, Judge, if Mr. Jones is not going to be available, he's not going to be able to participate. But as I said, Mr. Beal and I have talked about possibly getting this settled even through the telephone mediator, just a matter of whether his client can get us enough money to make Mr. Jones satisfied in some regard.
Do we know, okay, I get that. Are you asking me that you need more time than October 3rd? Than that deadline?
I think depending on Mr. Beal's schedule and mine and whether we can get it a date with the Dispute Resolution Center, I think we can probably get it mediated by that date.
Okay.
Judge, we may need some assistance in getting Mr. Jones available on video by Zoom for that mediation.
So I think you're reading my mind a little bit, Mr. Beal, because I was going to jump to if he's in custody, the court might be able to assist in maybe having him transported to the courthouse if you all had a date certain or a time certain, or if you want to do it remotely, whatever you find out from the jail they need. I know when we talk about attorney contact visits with their clients with laptops, I've signed those kinds of orders before. I think there's a few options there, but if you all can secure a date and time certain, I'd be happy to help facilitate that.
We'll work on that, Judge.
Yeah, I think we can, Judge. Yeah, that's a good option.
In terms of when I've had inmates brought over, generally I'll have them here in the jury room. And so even if a portion of that was happening with Zoom, so for example, Mr. Rojas, you have a laptop Zoom, you could be with your client in the jury room, a DO would be outside the door or inside. I don't know if that's
that makes sense and seems a feasible option.
Okay, well, let us know, figure it out. I'm going to leave the dates the same, except for I really don't think I need you all back on the 6th of September.
Okay, Judge, do you need us to file? It sounds like you're agreeing, but if necessary, do you need us to file a formal motion?
I want you to file a request for whatever it is that you all figure out is going to happen. If it's going to be done remotely and Mr. Riojas, you're going to be going to the jail and setting up with your laptop there, there's a request, that put that in your request. Or if you
Understood.
want him brought over to the court, put that in your request. But what we're going to need to know is when it's supposed to happen. So make that arrangement with DRO or whoever you're going to use to do that.
Understood.
Judge,
okay.
I think we need to push that September 6th case back at least a few days, a week or so, because I don't
thinking of
see it happening.
September 6th. I don't need to have you all here September 6th. Sounds like you all know what you're doing, and we have a deadline of October 3rd.
Okay, sounds good.
Okay.
Okay, Judge.
Works
right,
for
Judge.
me.
Thank you, guys. So Myrna, cancel please September 6th on this case, and then I will be awaiting your request for whatever arrangement you all come up with. Okay.
Understood, Judge. Thank you.
Thanks for your time. Who's next?
Bye.
Bottom of page 2, Judge.
Mhm.
In cause number 2022, DCV 0151, Pablo del Rio et al. Versus Lorraine Herrera. Announcement of council, please.
Chris Bertini for the plaintiffs, Your Honor.
Joe Garcia on behalf of Ms. Herrera, Your Honor.
Hey, everybody's here. That's good. That's a good thing. Final civil pretrial. I know you all have already gone to mediation and we're set for trial, ready to go.
Yes, ma'am.
Yes, ma'am.
So here's the court's issue. And Mr. Marufo, this is going to take some of your input here as well. So I had hoped, and Mr. Garcia, I think Mr. Bertini was here at the last hearing, and so I was understanding that this was a trial case. But I had mentioned that there may be some unavailability, I guess, from the court, because that's the annual judicial conference that week. And we have you all scheduled for jury selection on Friday, and normally then evidence starts on Monday. And what I have always had very good experience in is getting a visiting judge to cover. And here it was only for the 1 day of jury selection. Because of the annual judicial conference, they don't have anybody. They do not have anyone. Now, that said, That said, I think I had told you all we would start evidence on Monday, so I have a few options. Of course, me coming back early from the conference is one option, but I want to see if I can avoid that because then I don't get all those wonderful hours that we get once a year. You all are both out of town, correct?
That's correct.
So I have one thing. I can push you back to the following week, but I know you all have very busy schedules. I can put you on the 15th. We have our panels. We do a Friday jury selection. We start evidence on Monday. I don't know how that, if that is workable. That's option one. Option two is, Mr. Marufo, I see Monday panels. So that would be September 11th. We could, and I was thinking if you all are out of town, it might actually work better because you wouldn't have to get here on Friday. If we're able to steal some jury panels from these courts that have requested panels and do not go, then we could just do jury selection on Monday and roll right into evidence with your agreement. Either if we finish on Monday, start right then, or start on Tuesday and we're really only a day off, and then maybe you don't have to come to El Paso for the weekend. But I need to find out if I can do that and if your schedules will allow for that. One thing I have not asked, how long do you expect this trial to go?
2 days, Your Honor. And it's a car wreck, 3 witnesses, no language. I don't remember if Mr. Garcia's client has language issues or not. So it may not be a translation issue.
I don't think so, Judge. No.
Yeah.
So of those two, do you all have a preference?
Your Honor, I'm looking at my trial schedule. 9/11 would work. The problem is I have some preferential settings on some very old cases for the following week. Let me just look at one thing.
You mean the week of September 18th?
Yes, ma'am. I apologize. Yeah, I've got a really old case. It's almost as old as me, set on the 19th of September in Harris County. So I prefer, if we're going to go, we go on the 11th. And I'm assuming we're number 1 on the 11th.
Let me make sure. When I looked at this last week, when I kept getting some not good responses on the visiting judges. Let me see. I'm sorry, Mr. Bertini, what was your question?
Are we number 1 on September the 11th, assuming we go that day?
Oh, absolutely. You would be number 1 because you're just a carryover. I don't have anything else set in terms of a trial.
I'm just peachy keen doing September the 11th. I don't know what Mr. Garcia's situation is. Of course, I've got
a trial scheduled in Cameron County on that day. I don't know at this point if it's going to be settled in the next few days or not. So I do have that issue.
Well, I kind of figured your time would have been dedicated to this trial here anyway, because we wouldn't have started evidence until Monday. So what else?
That's all I have, Judge.
And, you know, assuming we can get a panel, Mr. Marufo, what's kind of the prospect of us? I thought I saw about 3 or 4 panels on that day. I think some had already canceled.
I believe that we're far enough, Judge, that I can secure in our courtroom 2 panels, AM and PM.
Do you all need more than 60 jurors? No, so we just need 1 panel.
Judge, also as a reminder, we're scheduled to start jury selection on Wednesday for Ramirez, Juan Angel Ramirez, Judge.
Oh, let me go back there. Let me see that. So we have it 13, 14, and 15. What do we have on those in terms of where we are on jury selection?
On the 13th, Judge, we're in Commissioner's Court. On the 14 and 15, we're here in the court with two panels each day.
Okay. Yeah. Okay, I'm still kind of okay with that. It means we're going to be a mess, but you all, I think, I feel like this shouldn't really take more than the 2 days. And if we
Correct,
did,
it shouldn't take more than 2 days.
and if we did, I still have them for panels on the 14th and the 15th. It's also not specially set, and he's not in custody. So you want to shoot for the 11th? And that way we're not messing up people's schedules too much. And I feel like we will be able to get a panel for that morning.
That'll be fine, Judge.
All right. All right. Okay.
Your Honor, can I represent to other courts that I have been assigned on the 11th?
Absolutely. In fact, I mean, you're assigned since the 8th. And
No, I appreciate that. I just,
Mhm.
some of these coordinators will challenge me, and I said, well, call the judge in El Paso and she'll tell her that I have to be there. So
By all means.
yeah, thank you
By
very
all
much.
means. So what I would like to do, having discussed that with you, is then if there's anything, obviously we'll start at 8 a.m. For anything you all might need to review pretrial, have our jury. I want to say they're requested at 9. And so we'll be here in the courtroom. That's just kind of how it'll go. And I'm happy to work as late as you all can, and all those things. So we can take care of it fairly efficiently.
I believe we have a pretrial. We have another hearing similar to this, I think the week or two before.
Oh, we should have our docket call.
Something like that. I'm sorry, Your Honor, I don't have my,
Let me go back.
I know we have something scheduled. I think it's the 3rd. You might be in your conference.
The 3rd, I will not. Where are you? Where's your case? Do you not have a docket call? Let me see.
We do, Your Honor. I just got to find it.
Yeah, I'm the same. Let me go back to today. It's on the 5th. So that will be the conference time. So I'm going to have again 2 options. We can handle the docket call at 8 a.m. on 9/11.
That's fine.
That's good. Okay.
Yeah,
Docket call.
I mean, if we have any pretrial issues, Mr. Garcia is a smart lawyer. He and I can work out things like motion limines and exhibits beforehand.
Beautiful.
And,
Definitely.
so,
Okay.
Mr.
So
Garcia,
then
are you down in the valley, or where are you?
Yes, I'm down in Edinburgh.
Yeah, I know where that
Okay.
is.
Yeah.
So we're looking at 9/11. That is pending confirmation. I want to make sure I get confirmed that we don't get any pushback on this panel. I don't anticipate we will, but we will let you know that. Okay.
And are we off the 5th?
You're off on the 5th because I will be in Houston.
And we'll hear from y'all as far as a jury panel, but for now we can then represent that we are set for the 11th.
Correct.
Okay.
Fantastic. Okay.
Okay.
Thank you,
All
Judge.
righty. Thank
See
you,
you on the
gentlemen.
11th.
See
Have a
y'all.
good weekend.
Take care.
Bye-bye.
Who's next?
Judge, bottom of page 3,
Mhm.
in cause number 2022 DCV.
Hold on. If we're going to go on to 2486, I want to make sure everyone else is taken care of first.
Okay, Judge, on page 2, middle of page 2, with Mr. Few.
Mhm.
I don't show nobody from Mr. Leafman David's office.
That one has been outstanding. Let's go ahead and call it.
Yes, Judge. In cause number 2022 DCV 0195, Juan Garcia Jr. versus EP Integrate Fire Systems and Concepts LLC et al. Announcement of council, please.
Good morning, Your Honor. This is James Fuel on behalf of the plaintiff.
And this is the case, Mr. Field, where Mr. Leftman has been kind of pending forever, it seems like.
Yeah, I don't know how to get him to appear, but we actually settled the case, and his
Okay.
clients are making monthly payments that are scheduled to be made out until October of 2024.
Okay,
We agreed to an agreed judgment, but it's never been returned to me from David Leffman. So I don't know if you just want to keep it until October 2024.
no, I would rather have some type of hearing on whatever the agreement is with that proposed agreed judgment. And if he signs off on it beforehand and that takes care of that, or if he decides to appear when we actually have the hearing on it, in any event, whatever relief you're asking for in anticipation of that being entered, and maybe that's something you can hold on to until 2024 and move on. But my suggestion is to do that. And so please file whatever you are going to have filed to present that to the court, and I will review it. And if he has signed off on it ahead of time, it's done. If not, we will take care of it then.
Very good, Your Honor. I will do so.
We do 30 days.
Sure.
Please file whatever pleading you are going to file with that and bring it to our attention so we can get the hearing set. Okay.
Absolutely, Your Honor. Thank you very
Thank you very
much.
much. All right, bye-bye. All right, there's Mr. Enriquez, Mr. Vasquez, and Mr. Lopez. Let's go.
Yes, Judge. In cause number 2019 DCV 4385, Dora Peña Marquez et al. Versus Ryan Rashad Howard et al. Announcement of council, please.
And let me stop real quick. I misspoke. It's Judge Enriquez.
No, that's fine, Your Honor. The only judge here is Honorable.
Good morning.
Good morning. I'm here on behalf of the plaintiffs, Your Honor.
Mhm.
I think it's a final pretrial. I've got a couple of motions that were filed this week on this particular case. I've had issues getting the defendant deposed, Mr. Rashad Howard. I'm asking some help from the court to get his deposition set. There's some insurance information that came up during the deposition of the corporate rep for Optimal Logistics, and I'm sure if Enriquez in the hearing, he will tell the court that his client in fact said that he rented the vehicle involved in the accident that Mr. Howard was driving, that he got insurance on the vehicle, which is a big deal for purposes of trying to get any kind of damages paid to the plaintiffs. At this point, they've been I guess they're representing, Mr. Lopez is representing the Optimal Logistics on an hourly and not through any kind of insurance policy. So it looks like we may have insurance. I filed a motion to compel that information as well through production. I know Enrique, I'm sure he is trying to get it from his client, and that's where we're at. I know we've got an October trial date. As far as the plaintiffs are concerned, we're ready to try it. But
Judge, let me ask, and so I'm clear on the record here, Mr. Lopez is here as well as Mr. Vasquez. Mr. Vasquez, are you there? I see his name, but I don't hear him. Can you please give him a call, Mr. Madufo?
Yes.
Mr. Enriquez, are we looking to set these for a hearing? There's a couple of things. I was going to suggest doing it before we have the final civil pretrial, so we're not waiting that long. So maybe we're looking at August 30th. August 30th. Also because the judicial conference is that week, so that's a bad week. But I see two motions to compel, the deposition and then this other information.
to be honest with you, Your Honor, I don't think that Mr. Vasquez is pretty easy to work with. He's told me that he'll get me the client if for whatever reason the client didn't show or whatnot. I mean, it's just a matter of having a court order so that he can show his client that he needs to show.
I'd like to set him for a hearing so we're not left pending anything because of the quick trial date. So, counsel, I'm going to bump up the final civil pretrial hearing to August 30th, cancel the 9/6, make it August 30th, And that will also be the hearing on plaintiffs' motions to compel. If there's agreement, everything gets resolved. Before that, you can let me know, and it'll just be a final check-in with you all to see if we're ready to go to trial or if there's something else
Yes.
that will be taking place.
It-
What do we
is-
have? Go
Is
ahead.
Enrique Lopez on the Zoom? here,
He
Mark?
is, Mr. Lopez is, Mr. Vasquez is box and his name is here, but he is not answering. And that's a little bit concerning. Did he respond?
His office said that he was on his way to federal court, but they were gonna send him a message to log in, Judge.
All right. We have another hearing that needs to go now. I'm going to go ahead and make those changes. You all will have the appropriate settings. And I know since you all have been working together, you'll continue to do that. Let
Oh,
us know if you need anything. If you need anything outside of those dates, okay?
Yes, Your Honor. Thank you so much.
Thank you for your time. Thank you, Mr. Lopez.
Thank
You
you.
go ahead and let Mr. Vasquez know that we'll have new settings for him.
We will. Thank you so much.
Thank you.
God bless.
Take care, you too. Okay, so Mr. Baeza, are you here on my summary judgment?
Yes, Judge, here on behalf of Ms. Labinati.
Okay, let me just make sure that's the only one left, right? And Mr. Kim is here on that one too. Okay. Good morning, everyone. Sorry, I didn't mean to make you think that you're not special. You actually were. That's why I wanted to get rid of everything first.
Thank you, Judge.
Good to see everybody. Okay. I will tell you also that, let's see, we're at 10:50. I think we have plenty of time, but I have a board meeting at noon, so I generally have to by 11:30. I do have various binders here. So let's get started.
In cause number 2022 DCV 4886. Let me repeat that, Judge. In cause number 2022 DCV 2486, Terry Finkley versus Pay and Save Inc. et al. Announcement of council, please.
Jonathan Baeza for the plaintiff.
Hugh Lyle for the defendant, Pay and Save.
Eugene Kim for EP Samana and Masita Investors.
All righty. And we're here on defendant Pay and Saves, no evidence motion for summary judgment, and traditional motion for summary judgment, and no evidence motions against EP Samana. Let's see. Traditional motion as to EP Samana and the cross action and brief in support. Mr. Lyle, I think this is your show for now. How about you get started and let me start taking some notes.
Okay, thanks, Judge. I think the court had actually also set this date for a status conference. And so what I'm, with the court's permission, what I'll do is I'd like to start off and kind of give you a bird's eye view of the case.
Sure.
This is, despite the fact that we've got 4 motions before the court this morning, it's really a pretty simple case. This is a trip and fall case that happened back in 2020. It happened at one of the Pay and Saves grocery stores located out on Dyer. I think there's 4 stores on Dyer, but this was the 9813 Dyer Street. And despite the fact that it is, we've got all these motions, it's a pretty simple factual case. From a status standpoint, I'll just let the court know that we have taken the deposition of the plaintiff. The plaintiffs have taken the deposition of a representative from EP Samana, and also have taken a couple of depositions of the Pay and Save people, the corporate representative and the store manager. And so I really don't think that there's any nuts and bolts, a lot of discovery that may be outstanding. I think we pretty much got everything in place. Now, the store, the mechanics of this case is that, and again, I'm going to, if anybody has an objection to this, they can speak up, but quite frankly, there's really not many questions about really what happened. The plaintiff was in the store with her elderly mother. They finished their shopping. They got a cart. They came out of the door and they were pushing their cart out to their vehicle, departing the scene, when an incident occurred in which the cart, the grocery cart that they were pushing, got its wheel caught in a crack, hole, ditch, whatever, between the sidewalk and the pavement of the parking lot. And in doing so, the plaintiff fell to the ground, the cart flipped over, and she suffered some injuries to her knee. Now, also, without, I think, any question, this is a situation where there is a shopping center there at this location, and the shopping center is owned, and the summary judgment evidence, the attachments to the motion show that the deed to this real estate went into EP Samana, and they own the real estate and then have these structures on it. EP Cinema then entered into a contract to lease the property to our predecessor in interest, which was back, if you can remember, back in those days, Judge, it was Big 8. It was a Big 8 store, and the Powells owned it. And as part of that, the purchase of those grocery stores from the Powells way back in the 90s, Pay and Save ended up assuming the lease that had been executed by the Powells, and that lease is actually incorporated and attached as the exhibit as well, and the supplements and amendments. The bottom line in this case, and the real reason why there's a rub, is that the Pay and Save leases the building from EP Cinema, Semana, and they have never owned and did not lease outside of the building, the common areas, so to speak, the parking lot, the sidewalks and that sort of thing. And so, given the fact that, Mr. Kim wouldn't be here, and EP Samana would not be in this lawsuit if this action had occurred inside the grocery store. The reason why EP Samana has been sued is because, well, we designated them as a responsible third party, and then the plaintiffs ended up bringing them in. I think, if I'm not mistaken, we brought them in as a responsible third party. The plaintiffs ended up bringing them in as a party defendant, and then EP Semana brought a cross action against us. So that's kind of the lay of the land as to what all is going on in the case. I want to start, if it's okay with the court, with the summary judgment that we filed on the cross action by EP Sanama. And Eugene, and forget if I'm mistaken about this, it's my understanding that even though I think you announced that you were here for Mesita investors as well, that they are actually have been amended out of the case. Is that accurate?
That's correct. That's correct.
So that part's out. Insofar as these traditional and no evidence MSJs on the cross section are concerned, it all really has to do with the construction of law. It's just a question of law. There's really not any factual disputes that I'm aware of. And again, heaven forbid I should make a mistake, but I don't believe there's any factual dispute. And it all has to do with the lease provisions. The claim, the cross action against Pay and Save was for indemnity under the lease. And under that lease provision, they're claiming in some is that if they're responsible, that PanSave needs to come in and indemnify the owner of this case for any of the claims brought by Ms. Finkley. Now, the reply has, and we base our claim for summary judgment based upon the 1987 Texas Supreme Court case, the Ethel case, which set forth the law in Texas as it relates to indemnity agreements. And that is, and I'm sure the court's familiar with it, but there was a lot back in the 80s having to do with, mainly came out of the oil and gas industry, but had to do with risk shifting indemnity provisions. And finally, it made it to the Supreme Court, and they recognized, the Supreme Court recognized in the Ethel case that you can, in fact, contract for indemnity and do it validly. However, in order for it to be enforceable, it has to be, you have to comply with what has now been termed the fair notice rule. And the fair notice rule has two parts to it. One is there is a requirement that these risk shifting clauses or phrases have to be conspicuous. They can't be hidden in fine print on the back or anything like that. They've got to be, it's got to be conspicuous. That's just one of the two components of the fair notice requirement. The second component is that if some party wants to be indemnified to include their own negligence, then that's where the Ethel Court came down and says that it has to say within the four corners of that document that the indemnity provision will extend to any negligent acts by the party seeking indemnification. Okay, and that's the express negligence doctrine. So in this particular case, I think we pled that and made motion that it wasn't conspicuous, but the truth of the matter is that it really doesn't make any difference if it's conspicuous or not. It's conspicuous in that it does not comply with the express negligence doctrine. It does not. There's no provision within the indemnity agreement in the lease that allows the enforceability of the claim for indemnity for EP Cinema's own negligence. And that's where we're at on this, as far as we just think it's a matter of law. It just doesn't meet the standard for the express negligence doctrine. The court, I mean, the reply, excuse me, the response that was filed cites the Dresser case, it's Dresser Industries versus Page Petroleum. And it's there, but it specifically says exactly what I just represented to the court, and that is that you've got to have not only conspicuousness, but you've got to comply with the express negligence doctrine. And that being said, it says what it says. It just doesn't. It's not enforceable for indemnity or shifting the risk in this case. That takes care. And I don't know how the court wants me to do it, but
I want you to stop right there. And now I'm going to ask to hear from Mr. Kim.
Sure.
Yes, Your Honor. The one thing that Mr. Lau left out in the same Dresser case that addressed the fair notice requirements for indemnity and defense is that there is an exception to the fair notice requirement. And the Texas Supreme Court held in Dresser, which came out in 1993, and that the fair notice requirements are not applicable when the indemnity establishes the indemnitor possessed actual notice or knowledge of the indemnity agreement. And this holding has been followed by the courts of appeals in Texarkana, Corpus Christi, and Austin, based on my research. Now, there may be other courts, but those are the three court of appeals that I've found, Your Honor. And so the burden of proof of establishing actual notice or knowledge is obviously on us because we're seeking indemnity and offense from Pay and Save. We sent out requests for admissions to Pay and Save, and their request for admissions number 9, 10, and 11 clearly established that they had notice and knowledge of this provision. I don't know if you want me to share my screen with you to illustrate this.
Sure.
Okay. So in Pay and Save responses to our request for admissions number 9, we asked them to admit that they reviewed the lease agreement before they assumed the lease agreement in October 16th of 2006, which they responded admit. Number 10, we asked Pay and Save that they were aware of the indemnification provision in paragraph 23 of the lease agreement on October 6, 2006. They admitted, and we also asked them to admit that they reviewed this same provision prior to October 16th of 2006, which they admitted as well. So clearly they had notice and knowledge of the indemnity and defense agreement as outlined. And the indemnity provision that we're talking about is in paragraph 23, which states that the tenant shall indemnify and defend the landlord from and against any and all claims, liabilities, liens, demands, etc. Of any and every kind in nature arising or growing out of or in any way connected with the use, occupancy, management, or control of the leased premises. And the basis for our cross action for indemnity defense is that we believe this incident arose out of the use and occupancy of Pay and Save's operation, which is a grocery store. And the lease agreement clearly states in paragraph number 8 of the lease agreement that it's a grocery store, right? And the landlord will not lease any other space to any other tenant that competes with that grocery store. And to further that illustration, in paragraph 22, I'll direct the court's attention to 22.2.3. The insurance requirements require the tenant to maintain a policy ensuring both the landlord and tenant against any and all claims arising out of or in connection with the tenant's use or occupancy of the leased premises, which also pretty much tracks the language of paragraph 23 for indemnification. So clearly they had knowledge and notice of this provision. Therefore, this fair notice requirement is not applicable, Your Honor.
Are you done, Mr. Kim, or was there something else?
Well, there's also one other provision I want to also kind of cite in 22.2.5. Let's see here. It basically requires that any insurance that the tenant obtains, they're supposed to add the landlord as an additional insured as well. And that also further illustrates our position regarding our cross claim for indemnity and defense against Pay and Save. And that's it.
Okay, anything else on that, Mr. Lowe?
Yes, Your Honor, and just briefly.
Sure.
And I don't profess necessarily to be the absolute sharpest tool in the shed, but I have read the Dresser versus Page Petroleum case. And the reason why it came up was because rather than a true indemnity provision, it was actually a pre-incident release. And so the court spent some time going through the analysis as to whether, you got to the same place, okay? Somebody was let loose for their particular negligence. And so the court in Dresser said that whether you want to call it a release or whether you want to call it an indemnity agreement, you still have to have the fair notice doctrine, and you have to have both elements, which includes the express negligence doctrine. That's exactly what this says, and it hasn't changed since Ethel came down. And there's no exception to it. It is the black letter law of the land that you have to have the express negligence written out and spelled within the four corners of that document to be enforceable. And Mr. Kim is right. We did, the Pay and Save did admit that they reviewed this contract before they assumed it. Okay. Now, just because we saw it doesn't mean that we agree that they don't have to comply with the express negligence doctrine. It's just like if it was conspicuous. It's conspicuous, and it's conspicuously absent of compliance with the express negligence doctrine. So maybe that's what they intended back then. I don't know. It's not ambiguous. It's a question of law for the court, and we believe that it's squarely within the express negligence doctrine requirement.
I think I've got it on that one. If that's all you have, Mr. Lyle, on that one, let's go to the next motion.
Okay. The next motion, I'm going to switch over, and we've got a no evidence and a traditional with regard to the claims of the plaintiff. First thing, let's go ahead and do a little housekeeping. When the plaintiffs filed this lawsuit, and under the current, I think it's maybe third amended petition, third or fourth, the live pleading of the plaintiffs in this case allege and a set of facts which are consistent with a premises liability claim. And that is that there was a condition that existed out there, i.e. this crack between the sidewalk and the parking lot that posed an unreasonable risk of harm. That's what they claim. Then they go to the next paragraph and they allege, oh, by the way, you're still liable to us under common law theories of negligence, of negligent, negligent hiring, retention, supervision, that sort of thing, active negligence. And so we made a motion, as the court is well aware, the case law is clear in Texas that you can have one or the other, but you can't have both. And given the fact that we now have just gone through the discovery in this case, it's all under oath, exactly what happened in the pleadings and stuff, that this is a premises case. That being said, we specially accepted to those portions of the plaintiff's live pleadings with regard to the active negligence claims. Those were included in our no evidence and traditional motions for summary judgment. And in response to that, no response was provided by plaintiffs on the active negligence cases. Okay. So insofar as those claims are concerned, we believe that summary judgment is appropriate. Then we get into the next part, and that is, as the court is painfully aware, the state of the law in Texas is that you have to jump through, a plaintiff has to jump through a number of hoops in order to prevail on a premises liability claim. And if any one of those elements of a premises liability claim are negated, then summary judgment is appropriate. And in this particular case, the key that we are turning on has to do with the control, and that is the summary judgment evidence is clear that Pay and Save never owned the real estate out there, and that Pay and Save only leased the inside of that structure, and that the common areas were retained, the control and right to maintain and the duty to maintain and make those areas reasonably safe for people walking up and down the sidewalks and parking lots falls upon the landlord. Now, and that's the crux is that we're not an owner occupier of those premises. And attached to the summary judgment, you'll see that there are it's nothing, there's no such thing as a free lunch. The landlord wants its money. I don't blame them. Landlord wants their money. They want rent. And then based upon a calculation, you can see in the lease agreement, based upon a calculation of square footage, then the landlord retains the right to maintain and inspect and do everything out there in the common areas. And then at the end of the month, then the landlord calculates how much it is that they spend on it. And then they're going to bill the tenants for their percentage ownership or percentage occupancy in that shopping center. But the deposition of the landlord's representative, who happened to be a lawyer, his deposition is attached to the motions and the responses, clearly shows that it was their responsibility, not just that that's what the contract says, that the lease agreement says, but that's the course of dealings was that they should have, that they were the ones that were responsible for maintaining it. He actually went even further in his deposition to say that, quite frankly, he didn't know, or his company wasn't aware of this particular condition, and that had it been observed, that would have been something that they should have, that the landlord should have fixed. Okay. But unfortunately, it didn't get fixed until after. And one of the things that we have attached is the fact that even you can look at control and over an area to determine whether or not they've assumed any of those responsibilities. And in that regard, because it's clear that we never owned the property and we didn't lease the property where this plaintiff was injured, there was a case that plaintiffs cited, and it, quite frankly, is not applicable. So the case that they cite is I believe it's the Walmart versus Alexander case. And they dug up this case, and it is trying to think if it's a Supreme Court case or not. I can't remember off the top of my head. Bottom line is, it's a case that's almost identical. And what happened in that case was that there was a lady who was injured because there was some sort of a defect, and as I recall, it was between the sidewalk and the parking lot. And the Walmart, it was a Sam's, but it's owned, Sam's is a subsidiary of Walmart. Sam's leased the property just like Pay and Save did, and they leased the building and not the parking lot. And there was a landlord there who was responsible for that. And so there was a question very similar to what we had here. Now, the big difference between the case what we have here and the case that has now been cited by the plaintiffs as being case determinative, the Walmart versus Alexander, is the fact that after they entered into this lease agreement, Walmart, without permission, went out and constructed the ramp that ultimately there was a settling of the pavement at the end of it, and it made about a 5/8 inch gap, and the lady tripped and fell. And Walmart defended pretty much like we have here by saying, hey, that's not ours because we just lease the inside of this building, and that is the property which is owned and maintained by the landlord. And in that case, it stands for the proposition that Walmart couldn't take that position because it had created that condition itself. And because it had taken the initiative to go out there and do that, that it extended the obligation to them, because it specifically talked about the fact that it was the area and the condition that was the subject of the plaintiff's injuries. That is the key. The key in that case that the plaintiffs put their eggs in their basket about is where Walmart created the condition. In this particular case, they have clawed, the plaintiffs have clawed and scratched and whatever, and have tried their best to try to, shoe spoon this deal, into that case. And it just doesn't work because there's no evidence whatsoever in response to the no evidence or in the summary judgment that there was any activity done by Pay and Save in either creating that condition or doing anything. And for example, the types of control that they wanted to extend under that Alexander case was the fact that out in the parking lot, we have constructed some cart corrals so that people can push their carts into that cart corral after they finish unloading their groceries. We have reported to the landlord, as an example, that we needed to have some of the lighting repaired because it was the light bulbs were out or that sort of thing. We had reported to the landlord that we thought that it needed to be striped. Those types of things are the extent of what kind of control we exercised over the common areas. The key being that we just didn't with regard to this area where the action occurred. Now, in addition to that, somehow or another, we are villainized because we have people that go out from the store throughout the day. This is the evidence, the responses, the summary judgment evidence, that we send people out there to get the carts and bring them back in. Okay. We expect our people to act reasonably. That's the testimony. We expect for them to act reasonably, that if they see something as they're getting the carts, we expect our people to report anything if they see something dangerous, and it's therefore reported so it goes up to the landlord for them to do something about it. Our testimony, the corporate representative testimony, was simply that we expected them to use their common sense. Not that we went out there and had somebody go out there. There's no evidence whatsoever that we had anybody whose responsibility it was to go out there and look for defects such as the one that existed. What you see in the summary judgment evidence is that there are computer records from the landlord that shows that they would go out on a periodic basis and inspect the entire common areas and effectuate repairs either personally or either in-house or by hiring independent contractors. None of that had anything to do with Pay and Save. So bottom line is, both under the no evidence summary judgment and in the traditional summary judgment, the claims against Pay and Save fail because the person or the entity that was the possessor, owner or possessor of the premises where the incident occurred did not fall under Pay and Save, number one. Also, and it's, as I was reading through the responses, the thing that jumped out at me, probably as much as anything, is being loose, I guess, with the term premises. Okay, well, no question, the plaintiff fell on a premises. It just didn't happen to be a premises that was leased or under the control of Pay and Save. And that's the big rub. Anyway, for those reasons, simply because they fail in an essential element of the cause of action for premises liability in Texas, along with the fact that they didn't respond at all to the negligent acts, we believe that it's appropriate for summary judgment to be granted. And this case isn't over. I mean, it's not like the plaintiff is getting a raw deal on this deal at all. It actually much simplifies this case because the premises owner is before the court, but just not the innocent tenant. Thank you, Your Honor.
Thank you. Mr. Bessa?
Thank you, Judge. First, I will be.
Give me, Mr. Bessa, I'm sorry to interrupt. Give me like 30 seconds. You don't
Sure.
need to get off of YouTube.